Joining me now is Jess Miers. She's a senior counsel at the Chamber of Progress, a left-leaning tech advocacy group, to talk about this further. Jess, thanks for taking the time to be with me. What's the reality from what you've seen about how much conservative content is censored on these social media platforms?
Yeah, thank you so much for having me as well. There's actually been a study or two on the types of content that is most likely to be removed. Now, this study was done back in the pre-X days, I believe, but the study was done on Twitter, and it actually showed that liberal content from the left, was actually more likely to be removed or deplatformed than conservative content. So the way in which these laws are sort of arising out of this, anti-conservative bias that has been discussed throughout these two cases is not actually aligned with what we've been seeing.
Because also, I mean, it's not just conservative speech. I mean, why do these states also want to protect? There's some posts that have misinformation. Hate speech could even be an issue going forward.
Yeah, that's kind of the root of it as well. I mean, we saw both in Florida and Texas when both of these laws became enacted. The right championed that these laws would be used to keep liberal viewpoints and ideologies kind of at bay and allow for more of these conservative viewpoints to flourish. And that's usually the type of stuff, considering, and we heard the justices bring this up today, COVID misinformation, for example, election disinformation. So a lot of what you're hearing the experts discuss is that these laws very much represent the ability for these sort of right-leaning or more extreme groups to be able to keep their more extremist and harmful information online at the cost of other relevant, high-quality information.
If the court, let's look into the future when the ruling comes down, which won't be for a couple of months, if the court sides with Texas and Florida, upholds their laws, what could that mean for what social media looks like in those states?
Yeah, we'd be looking at a very different sort of internet. And we could really, this was very clear with the way in which the Texas and Florida attorney represented these cases today. I mean, look, Texas and Florida starkly outlined their vision for the internet. They are looking for a space that's dominated by the loudest voices, that foster content that endangers marginalized groups and younger audiences. And they've also sent a very clear message to their constituents. They'd prefer to see these platforms actually leave their states entirely. We heard this from the Texas attorney, rather than allow them the freedom to editorial discretion. There's sort of two ways that this could go if they're affirmed. We will see, we could see these companies decide, look, it's consistent. We are consistently moderating content if we just leave everything up, for example, and we take a hands-off approach. And you could imagine what a hands-off approach to the internet and content moderation might look like, how awful our feeds might look like. That's unlikely to be the realistic approach, though, especially for some of these major companies where they have interests in keeping their users and their advertisers happy. These advertisers don't want to see their products being put next to really awful speech like COVID disinformation or even anti-Semitic information. And so what we're likely to see is these companies go the opposite way, and they put even more restrictions down. They decide, look, we're just not going to host user-generated content, at least in the states of Texas and Florida, because it's too much of a legal liability.
I want to bring up Section 230 of the Communications Decency Act of 1996, which, if you don't know what it is, people at home, I know that sounds like very boring government stuff, but I mean, this is a law that ultimately means that social media companies cannot be held responsible for what someone posts on their platforms. How could this impact the cases that we're talking about right now?
We heard a lot of confusion from the court today, just about whether Section 230 contradicts the First Amendment or whether the First Amendment contradicts Section 230. I think it's important to remember, and the government made this point as well, is that Section 230 is purely just a procedural law. All Section 230 does is it helps these companies and users reach the inevitable conclusion that they would reach without Section 230, and that is that the First Amendment protects the ability for private services and private users to engage in editorial discretion. Now, if the court decides that both of these laws are entirely unconstitutional and they violate the First Amendment, then Section 230 is actually moot here. We don't have to reach the Section 230 question because there's no First Amendment outcome for the law to facilitate. So I think the justices struggled a bit to understand sort of the interplay between the First Amendment and Section 230. But the reality is that this is a First Amendment question, and the question of Section 230 is one that's much later down the road.
Okay, and then all of this, of course, happening during an election year. What could this mean for the information we see as we head towards November?
Right. This is a crucial period. This is the time where everybody is learning about where they can vote. Everyone is learning about the different types of campaigns and platforms that folks on both the right and the left are running on. And the internet is a crucial part of being able to get access to information to inform voters about how to participate in democracy. And so depending on how these cases go, again, election information is some of the most risky or in terms of liability, some of the most risky type of content for these services. And so if these services decide to go in the direction of removing content, then it could become very difficult for users like myself and others to be able to get more information about the democratic and election process.
Jess Miers with the Chamber of Progress. Thank you for your time. We appreciate it.
Thank you so much.